Gentleman's time has expired. The chair recognizes Mr. Waxman for 5 minutes.
Thank you, Madam Chair. Again, looking at this draft bill, I have some questions so that we can get your input on it. And as I look at the draft bill, there's a notice that must be given to the Federal Trade Commission and the consumers when there's been an electronic data breach. But it's only required after the covered person, the company who has the identifying information, has done certain things in connection with the breach. The covered person must, one, assess the nature and scope of the breach, makes sense, take steps to further prevent breach or unauthorized disclosure, and then three, restore the integrity of the data system. Now, those clearly are the priorities for the company itself. After they've done all that, the covered person must determine the risk to the consumer, and after they've reached that conclusion, within 48 hours, they're supposed to give the notice to the FTC and the consumer. But there's no limit in this draft bill for how long a person can take to complete steps 1, 2, and 3. There's just no limit. The covered person, company, knows about a breach. Could take a week, a year, maybe 5 years, and then within 48 hours of that, provide notice to the Federal Trade Commission and the consumers. The bill from the last Congress included an outer limit of 60 days from the discovery of the breach to provide notice of the breach. That outer limit has been dropped from this discussion draft. If we were to include an outer limit, how long should that limit be, in your opinion?
In my view, and the Commission's view, is that the time for notification should be as soon as practicably possible. That may differ depending on the circumstances. I believe that 60 days should be at most an outer limit. Again, our view is that the sooner the better. The sooner that notice is provided, the sooner that a consumer can take appropriate steps to protect and try to mitigate any harm that may result from a breach. So I don't believe that there's a particular number that I can give you sitting here today, because it may depend on the circumstances, on the nature of the breach, the size of the company, but I would say that the 60 days would be at most an outer limit. 60
days wouldn't be an outer limit, but as soon as practicable, that
yes.
information ought to go to the consumer that their identity has been compromised.
That's correct.
By the security leak. Thank you for that. The discussion draft provides an exemption from the bill's data security requirements for entities that are subject to data security requirements under different bills, the Graham-Leach-Bliley or the Health Insurance Portability and Accountability Act, or for any activities governed by the GLB and the HIPAA. Now, this is a departure from last year's bill. Last year's bill only said that compliance with these two other statutes meant you were in compliance with the requirements of this legislation as it was drafted, provided that the requirements of GLB and HIPAA were similar or greater than those required under last year's bill. The language was not phrased as exemption for entities subject to FTC jurisdiction, but rather as an alternative means of compliance. It's unclear to me whether under the draft bill, the Federal Trade Commission maintains the ability to enforce any data security requirements against those entities, or if the safeguards in those other laws must meet or exceed those in the discussion draft. Do you believe that this exemption could potentially limit the Federal Trade Commission's enforcement abilities with respect to entities subject to the other two statutes, those other two statutes, and could you explain your answer to that?
Under my reading of this of the bill, I do believe that it potentially creates a gap in authority, because it does exempt entities that are subject to FTC jurisdiction from having breach notification requirements, which are not required under Graham-Leach-Bliley. So that is a concern about there being a potential gap in authority.
And do you believe this exemption could potentially lead to a disparity in the security requirements for non-bank financial institutions and everyone else under the FTC?
I do.
And what's your understanding of the effect of the phrase, any activities governed by the GLB or HIPAA on the scope of this exemption. What is the Graham-Leach-Bliley activity? Is that just issuing privacy notices? Is that following the FTC safeguards rule, or is that marketing?
That activity-based exemption, it's a little bit unclear exactly how broadly it might be interpreted, but I think that the key point is that it does create a disparity between the obligations of certain financial institutions, so that it is a concern about in connection with the authority that's provided.
Thank you. Madam Chair, I just want to point this out as an area where we need to work together to make sure that there's no ambiguity or poor drafting that would undermine what we're trying to achieve.
I thank the gentleman very much. I agree with his questioning and agree with his assessment about where we can fortify the bill, and I look forward to working with you on that.